Welcome everyone to our webinar on Disputes 101, how to navigate a business dispute. My name is Jodie Thomson and I'm a practice leader in LegalVision's disputes team. Before we begin, a couple of quick housekeeping items. First of all, you'll receive a recording and slides of this webinar in your email afterwards, so you can keep that and have a look at it if you have any questions. If you've got any questions about a business dispute, you can submit them into the Q&A box and I will answer them, or I'll have a go at answering as many as I can in the time we've got at the end of the webinar in the Q&A section. And also, would you please complete the feedback survey after the webinar? We'd be very grateful for your feedback. For the next 48 hours after this webinar, you are eligible for a free consultation with LegalVision to discuss how we can help your business. If you provide your contact details in the survey at the end of the webinar, then we can arrange that for you. So today we're going to be talking about business disputes, and what we're going to cover is the type of business and contract disputes, which I'll explain when I get started, and how they start. We'll talk about the first steps that you need to do if things go wrong, if it looks like there is a dispute starting or likely to start. How to resolve your dispute without going to court. What happens if you do go to court, and finally some tips on preventing disputes in the first place. And then, as I said, we'll finish with a Q&A section at the end. We'd also be grateful if you could answer a quick poll question for us. The question is, what is your primary concern when facing a business dispute? Is it maintaining business relationships, minimising financial impact, understanding your legal rights and obligations, avoiding court and legal costs, or just learning no current disputes? We'd be grateful if you could let us know. It helps give us some information about what information that you need. Now, the first topic that I will talk about is types of business and contract disputes. As I said, we're focusing today on disputes that you might have with other businesses or companies who your business interacts with. It's obviously a very large scope of topic, but there's a few common themes and certainly a lot of general advice that I can give you today. Most of those are what we call contract disputes, and it might be to do an agreement that you've got with another party or company about some money owing, about the quality of the goods or the services that you're providing or they're providing. You don't need to have signed a written contract for us to refer to there being a contract. Legally, there can be a binding contract in place where the parties have agreed, might be by email or text or by a conversation and then performance of the contract. And this can cover a whole range of different business disputes. It might just be about those services or the money, but we do contract and business disputes that cover things like commercial and retail leases, some employment disputes between businesses, loan disputes, business sale disputes. There's a whole range of them. But as I said, a lot of common issues come up in how to deal with them, and so that's the assistance we'll be giving today. Some of the common types of business and contract disputes include where one party has breached a contract or what they're supposed to be doing in terms of the contract. As I said, might be failing to pay. It might be providing poor services or defective goods. The contract itself might have some unfair contract terms in it, and it might be unclear. So the parties might be in disagreement about what their agreement is in terms of what needs to be done, what was going to be agreed. One of the most common business disputes that we deal with is terminating a contract. So perhaps one party wants to end it or the other party wants to end it. And that's very, very interesting and can be difficult to get out of. It's a common dispute that we do have. Just a quick reply on your answers to the poll questions. Thank you very much. It looks like 37% are concerned about maintaining business relationships, 34% minimising financial impact, 41% understanding legal rights and obligations, 22% avoiding court and legal costs, and 44% just learning. So all of those issues will be covered as I'm talking through today. So thank you for responding to that. The next thing I'm going to talk about is the first steps to take if things go wrong. And what we see in the work that we do is that disputes can often be resolved very quickly at the start, or in fact managed before they become a dispute. And it is important to have an understanding of how to approach these things. It's a bit like diffusing a bomb. If you do it very carefully and delicately at the start, you can avoid it turning into a big explosion that will have costs and other repercussions for your business. What we generally recommend, and it really is the key to resolving a dispute as quickly as possible, no matter how angry you are or aggrieved at the other side, or that you feel that the other side may have done something wrong, is to take a good faith approach. And that means to look to communicate and negotiate to try and resolve it. Take the approach that you're not going into war, but you're looking at solving a problem together with the other side. Even if it's the fact that you end up parting ways and no longer being in business together in some way, you're more likely to get a quick resolution if you have that mindset when you go into it. So it can mean, parking your emotions or trying to keep a neutral approach to any emotional reaction that you might have. That's a common discussion we have with clients when they come to us with a dispute. Communicate and negotiate. As I said, talk to the other side as a starting point. Provide information if the other side is asking for it. Explore ways to try and resolve it. Some things to do that we don't often see clients doing is putting things in writing. So being very careful about if you're the one making a complaint or raising a claim or an issue with the other party, spell that out very clearly in writing. I'll keep repeating this over and over again, but try and keep emotion and anger out of it, even if that's what you're feeling. Take notes if you have a phone call or a discussion with somebody. Keep a written record, because if the dispute does escalate and you need some legal assistance at a later point, it's very important to have things in writing. Your memory might not be as reliable as you would hope if it was some weeks or months after. We spend a lot of time taking clients through particular phone calls or conversations that might have happened many months or longer ago, and it can be hard to remember. So some sort of file note, even if it's a handwritten note, is very, very useful. If things are going wrong, go back. If you've got a written contract, you've got some written business terms, or the other side does, and you've signed them and agreed to them, go back and have a look and refresh your memory about what they say. If there is a written contract, have a look to see if it has a dispute resolution clause. Many contracts do, and that's a special process that's set out in your agreement for the parties to work through if they're in dispute. If for some reason there's a concern with the contract or services or the payment and you're not in agreement, it can help you to work through that rather than trying to freewheel it outside of those provisions. The main purpose of dispute resolution clauses in contracts is exactly this, to try and help parties resolve it, and very much to stop one side running off to court or running off to lawyers and issuing court proceedings, which can just make it a lot more difficult to resolve things quickly. All of this process, of course, helps you narrow the issues in dispute. We often have clients come to us with a business dispute, and that they'll read us out a whole shopping list, for example, of things that might have gone wrong with a service provider. But when it comes down to it, it might only be one element where they have a legal basis, or that it's worth taking some legal action, or that they might have a claim for damages and it's worth taking action. So again, it can be a case of picking your battles, but narrowing those issues in dispute so that you can really focus on what outcome you want and how to resolve that. If there's a dispute that's not going to be resolved by conversations in the first instance, and it doesn't feel that you need legal advice at that stage, there are a number of organisations and bodies that can help, that we see a lot of clients either come to us after they've been to an organisation or a body that can help, or we might refer them on to, if it's a matter that might not be appropriate for court or needing a lot of legal attention. For example, most states have a small business commission that runs, I know New South Wales and I think Victoria runs their own mediation service. I'll talk about mediation a little bit later on. That is very cost effective, that is designed to help businesses resolve business disputes. And it can be a lot cheaper than being in a big legal battle with lawyers involved and possibly court proceedings. It might be that the fair trading or the consumer department in your state has an early dispute resolution process that you can help. But if in doubt, and if you think there are some serious risks to your business, if you're owed money or you have another business claiming money from you, and you're very concerned about it, then we do recommend getting legal advice. Even if it's as simple as having a consultation with a lawyer, like somebody in our team, who can map out for you what your legal position is. Do you have a claim? Does the other side have a claim? Regardless of what the answer is there, what should you do? What are the options and the strategy? Sometimes you can leave it at that. It might be enough for you to go away and manage things on your own. Sometimes we are in boots and all, and we're writing letters and representing our clients fully. And sometimes we might be taking a more arm's length or a backseat assistance, where the client's happy to manage communications by themselves, but we might provide some advice in the background, might review an email or give some guidance for a meeting or a call. The next section I'm going to talk about is how to resolve your dispute without going to court. So following on from some of those first steps that you need to do, what we recommend is to try and talk it out first. Where possible, it's better to have a call or a meeting with an individual where you can discuss your concerns. Things can escalate very quickly when they're not expressed well in an email or even a letter, and it can blow up more quickly than it should. So if there is any way of resolving things with a call or a meeting, it's a really good place to start. As I said earlier, take notes. The next step, or perhaps alongside that, is putting your position in writing. Either do it yourself or have your lawyer write a letter or get some guidance from a lawyer about what to put, and make it very clear, and try and focus on a particular issue that you want to result on, and keep it narrow in terms of making it very clear what your concern is, or your claim is, or your response to their claim might be. When it comes to writing letters, if you've got a lawyer acting for you, they'll manage this and explain it to you. But there are two types of letters that you can write to another party if you're in a legal dispute. The legal terms that we use are, one is an open letter or open correspondence, and the other one is without prejudice. And to simplify, what that means is that open correspondence is where you're setting out your legal position and making a claim. For example, it might be that the other party hasn't paid your invoices and you set out the full amount that is owing. Sometimes to resolve a dispute, you might be prepared to compromise. They might owe you $100,000, but to resolve it and move on, you'd be prepared to accept $75,000. If you're going to make a compromise offer like that, then that should be what we call without prejudice communication. And anything put in writing should be marked without prejudice. And what that means is that it can't be used in court as evidence to confirm that only $75,000 is owed. It can get a bit more complex, some of these legal rules, but we do see a lot of clients come to us and have made offers, settlement offers or compromise offers, and they haven't in any way marked that correspondence without prejudice. And if things do blow up and end up in court later on, that can be a problem. So that's the type of thing that we would just say, if there's a lot of money at stake or a serious risk to your business, it really can be worth getting a lawyer to help, because we just sometimes see clients have got themselves, they've got themselves in a bit more of a mess than they might have needed to if they didn't have a lawyer involved. As I referred to talking about offers, the one thing we would say to try and resolve a dispute without going to court is to be prepared to compromise. Now, it's often a difficult thing to explain to clients who are very aggrieved. And again, just to keep to a simple debt recovery or money owing type example, if you think that the other side owes you a certain amount of money, you might feel very reluctant to compromise, but sometimes it can be a good way to resolve it. And that small compromise, it might be accepting that $75,000 rather than $100,000, might be the difference between resolving a dispute so that you and the other side can get back to work, get on with business, and not have your time and attention taken by this dispute, versus a dispute that can go on for a long time. I'll talk a bit more about court later on, but we have disputes, we have clients and disputes going on that have been going on for 1, 2, 3 years, with a lot of legal costs in that time. So there is a real benefit to your business in trying to resolve it quickly. On that note, consider the costs. And it's not just legal costs if you have a lawyer involved, but it is that time and stress away from your business. And if you do have to go to court, that's a whole different time. The other thing just to mention about resolving a matter without going to court, if you have a lawyer involved or if there's a lawyer on the other side, they might make and you come to an agreement with the other side. Again, it might be, let's agree that you will accept $75,000 for those invoices. We would always recommend that you capture the terms of that settlement agreement in a deed of settlement. It's a legal document. It's usually fairly straightforward for lawyers to draft, depending on how complex the terms of your agreement are. But what it does is that it gives you a legally binding document that both parties are obliged to comply with. It ensures that your payments are made within a certain time and whatever's agreed, but it also ensures that both parties don't take the matter further. So it finalises things properly. That's something that is, in most cases, that we would do when there's a dispute. If it is resolved, there's usually a deed of settlement between the parties to finalise that. Before I talk about going to court, I do want to just talk about mediation, which is something that you may have heard about, but not really understood how it works. It's a process whereby a dispute is resolved without going to court. Sometimes it might be that court proceedings are started and the court refers the parties to attend mediation to see if they can resolve it before going on with a long and expensive court process. The figure I've heard used in terms of success rates for mediation is about 80%. And I think that would fit with our experience in the mediations that we do. They're usually a half day or a 1 day. They involve both parties. The mediation is run attending together. It's run by an independent mediator who's most often a lawyer or a barrister and an accredited and trained mediator who doesn't act for either side, is not providing legal advice, but helps the parties go through a mediation process to deal with all of the issues in their dispute and try and guide them to a result. And most often finalised with a deed of settlement if there is a result. So when you hear people talking about mediation, what that involves is it's that meeting together with an independent mediator. Now, we have clients who attend mediation with a private mediator that we help arrange. Perhaps they might go to their local small business commission who can arrange a mediation. Or again, sometimes if matters are in court, the court might send the parties away to say, can you lot all attend a mediation and see if you can resolve this before you go ahead with it. If all else fails and you do need to go to court, I could spend a whole webinar talking about this, but just to give you an idea, and we find when clients come to us, they often from the get-go, particularly if they have a claim against the other party, they're very keen to go to court. Usually from what they've seen on television, which makes it all look quite quick and a little bit easier than it is in real life. We spend a lot of time talking parties through all the processes that I've talked about today and explaining that court is a very, very serious and expensive undertaking. What's involved in going to court is one party making a claim against each other by preparing a court claim in a particular form that's required depending on the court, and filing that claim in court, might be a local, district or Supreme Court, it's a little bit different in every state, or a tribunal. Most states have a lower or a smaller body like VCAT or NCAT if you're in New South Wales or Victoria. There's an equivalent in each state. It's all considered litigation or legal proceedings to resolve a dispute. The broad process basically is the party making the claim files the initial claim. The other side has a certain time frame to respond and put on their response or their defence. Then the court makes some orders for the parties to file their evidence, which is usually affidavit evidence of any witnesses, and lists the matter for a hearing. The hearing might be 1 or 3 or 5 days, usually for the type of commercial disputes that we do, sometimes longer. But that whole process from beginning to final hearing is not done in less than 6 to 12 months, very often longer, and it's very, very expensive. At least your legal costs to your lawyer to assist with managing whether you're initiating a claim or defending it is likely to be at least $100,000 or more, sometimes many hundreds of thousands of dollars. And it's difficult to stress how time consuming it is. There's a lot of meetings, a lot of documents to put evidence together, a lot of time going through those court processes before you get to the final hearing. If you win or if you're successful in your claim, the court may order that the other side pays your legal costs, but you never get 100% of your out-of-pocket costs. Roughly speaking, you might get 60 to 80%. But it can be a long time before you see that money, even if you do have a costs order. Sometimes with smaller claims, and when we say smaller claims, that's the monetary value. So, for example, a debt recovery claim of less than $20,000. The smaller courts, so the local courts often have a small claims division, again, or the tribunals might deal with smaller claims. And they're designed for parties to represent themselves. You don't necessarily need lawyers, and they keep things very informal and straightforward. But it's still very stressful, and it's still a lot of time taken away from your business. If you do have a lawyer involved, what we find, and this is what's difficult, is that the steps that are involved for a lawyer to prepare the claim, prepare the evidence, give clients advice, attend all the various court attendances that are needed in the lead up to a final hearing, often take as long for a $20,000 claim or a $50,000 claim as a $200,000 claim. So that's where we will often talk to clients about, again, when I'm talking a claim amount, it might be a simple debt recovery. It might be the amount of damages that you are claiming from the other side if they've provided poor services, for example. We very, very roughly would often talk to clients about the fact that if your claim amount is less than $100,000, it's often the case that it's not commercial for you to go to court. And that's all part of the advice that we give when we're looking at a legal position and strategy and so forth. Being part of the costs of going to court are that you would nearly always need a barrister, counsel, as well as a lawyer. Barristers are case law and advocacy specialists, and they are the ones who spend all of the time in court, and nearly every party in a major court proceedings has a barrister. So that's an extra cost. But it's uncertain and risky and unpredictable. Different judges, different courts, even will have different processes and different results. And even if your lawyer tells you that they think you've got a strong claim, there's never a guarantee that you're going to be able to win. So there's a risk that if you go through a court process and you don't win, not only do you not win, but you might have to face a court order that you pay the other side's legal costs as well as your own legal costs. One thing just to say about going to court as well, just very quickly, is it's always worth considering checking in with your insurer if a dispute arises, whether or not they might be able to assist. But for my final topic, before I finish the webinar, is to give you some tips on preventing business disputes so that you don't have to deal with any of the things that I've been talking about today. And we do see a lot of similar patterns with our clients who do come to us. As I said, there's a lot of similar themes, similar things that have gone wrong before they've come to us. So it is really worth being mindful of some of these issues that I'll be talking about to see if you can avoid a dispute. One of them is to be familiar with your business documents and agreements, if you've got them, and to regularly review them. Now, they might be your own businesses, contracts and terms and conditions that you provide to other parties when you are engaging with them. Perhaps you're engaging a contractor or a service provider. It's often not until a dispute arises that people discover that there's a problem with their business documents. Maybe some of the clauses aren't going to work as well as they should. And that's perfectly normal. We see it a lot. We have a contracts drafting team who are often updating clients' contracts because their business might change, things might change. It can make a very big difference to how a dispute rolls out. Because the first thing we do is, usually when there's a dispute between parties, is we will ask to be provided with a copy of all the contracts. If it's a case where you have signed contract, or you've entered a contract, or you've entered some sort of business agreement with the other side, to understand what the terms are. Often these days things are done online, and you might be clicking a box that says you accept their terms and conditions. Have you read those terms and conditions? Do you know if you can get out of that contract if you want to? On that basis, we do strongly advise, if you are entering a business contract that's got significant risks and costs and is a big deal for your business, it is really worth getting some legal advice before you sign. One of the most common disputes, I think I mentioned earlier, that we do have is clients who want to exit or terminate a contract, and they don't realise that the terms of their contract have locked them in. They might be locked in for 3 years or 5 years, like a mortgage. You can be quite trapped in it, and extracting yourself from that can be very risky and very expensive if you don't do it properly. Similarly, you might want to get rid of another party that you are engaged with, and that can be a problem. Last of all, we do recommend, and I have said this before, when you're dealing with a dispute, or when you're dealing with any other business partner, then it's good to keep egos, emotions, and feelings in check, because we often see disputes arise just because we're all human, and things might have blown up, but it can really make a big difference to stop them escalating if you can keep those emotions in check from the start. That's something we talk to our clients about. That's the end of the formal presentation part of the webinar. There's a publication that you might find useful. It's our guide to resolving business disputes, covering a lot of the material that I talked about today in a little bit more detail. So you're welcome to download that if you would like some more information. And you might also be interested in our next webinar, which is expanding into the US, what every business should know if that's something for your business. Before I go into the Q&A section, we'd also like to give you some information about becoming a LegalVision member. It's a subscription service that we offer to clients for a range of services, and it gives you access to 100+ experienced lawyers, and it can be a really great way for businesses to get legal advice in a cost-effective way that's going to target exactly what their business needs. All right. I'm going to answer some of your questions now. Bear with me while I just check what questions that we have received. And thank you to people who pre-submitted questions. That's really helpful. First question is, if a client doesn't return hired goods and stops paying, is it classified as theft? And who should I contact about it? This is a question that we've had come up in quite a lot of different disputes, and there's a difference between what we do in commercial disputes is it's what we call civil law, and that is different than criminal law. And sometimes people might be committing a crime as well as a civil breach or a commercial breach. In this case, I would say that if, well, without seeing the details of the contract, but I would say that that person is in breach of the contract. So you could make a legal claim against them, a civil claim for damages resulting from the breach of contract. For example, the cost of the goods or any other financial loss that you've suffered. But there might also be a criminal claim for theft. We're not criminal lawyers. It's a very different area of law. But you could certainly always contact the police if that was the case. Quite often what we find when clients come to us and they've had a matter like that is they've gone to the police and the police have said, oh, there's a, is this part of a contract? You need to go and talk to a commercial lawyer. But that's certainly something that you could consider as a first port. What's the best way, next question, what's the best way to approach a conflict between parties? Well, tapping into the same points that I mentioned in my webinar, calmly, in good faith, you've got a better chance of success and being able to come to an agreement if you think of it as working together rather than being at war, because that's what it feels like if you end up going to court. The best thing for your business is always going to be to try and resolve it quickly. Mediation is a great option to navigate an early conflict in that way. One of the other questions that's just come in is, a business is not paying on time as per the agreement. What can we do to resolve this ASAP? And we would certainly one of the most common issues that we do, and it falls into a debt recovery category. And what we would recommend is issuing a formal letter of demand, putting that party on notice that they owe you money, how much, resend a copy and attach a copy of the invoice, if there's an invoice amount. And that formal solicitor's letter of demand is would set out that you would go to legal proceedings if they don't pay. You can get a solicitor to send a formal letter of demand. We have a large debt recovery practice, and they're very straightforward, and they're actually included in the membership, LegalVision membership service. Sometimes debt collectors can offer that service, but they can't really go further if there's a complex legal matter. Once we've sent a first letter of demand, you can send a follow-up letter of demand if they don't pay in that time. Usually it's a hope that the threat of legal proceedings is enough to get people to pay. And what we usually see is that if parties aren't paying, it's usually for one of two reasons. Either they can't pay, they might be having some financial problems themselves, or they won't pay because they've got a dispute or a concern about your services. But you need to find that out. So that's what we would recommend, trying to work out as quickly as possible. Another question on a client would like me to sign over all business IP for work produced which sits outside our agreement. They would like me to dissolve the current agreement and sign theirs. So if this issue came to our team, the first thing we would say is legally, there's no obligation for you to dissolve an agreement and agree to their demand. You can consider it, and if it suits you to do so, you might accept it, but you might want to negotiate. We would want to have a look at the agreement, and we would ask questions like, what's the term of the current agreement? How long does it go for? Are you locked into it? When does it end? Can either party terminate for convenience, we call it? So perhaps you just give 30 days notice. And we also always ask clients, and in this case, what do you want? What's going to work best for your business? And if staying put is going to work, then it can be better to do that. It is worth getting legal advice when it comes to IP issues. We've got a number of IP lawyers in our disputes team, because there can be some really long-term financial impacts if you don't have the right protections in place for your IP. A question about shareholder. Now, this falls slightly outside of a business-to-business dispute, but I can certainly answer it quickly. The question is, if a shareholder wants out and asking for money they paid for shares to be refunded in full, and this is currently not possible, presumably what do we do? Yes, that's an internal company dispute, but the simple answer is that shareholders aren't entitled to be paid out for their shares. And there's also an issue of the amount they paid for the shares. The value of the shares can change over time. So what they paid at the beginning, the company's value might be less, might be a few years down the track. So what their shares are worth, it may be less. So there's a whole lot of different issues. We do a lot of director shareholder disputes, and I've done webinars about those topics as well. So you're welcome to come back if you'd like some more information about that. Another question here about if a supplier invoices you for the whole month without providing the service and then tells you that the services have been withheld without notification, what can you do? You've paid the invoice. In that case, I would be wanting to communicate with them and find out why they're withholding the service. That's a breach of the agreement again, whether you've signed a contract or not. And you are entitled to claim from them either that they perform the services as they're meant to, that you get your money back, and perhaps looking at whether or not they breached the agreement and whether or not you want to terminate that agreement. It might depend on the contract terms, but that's a very typical example of the type of disputes that we see. And so to your first question, what can I do? Depending on the relationship and whether or not they're communicating with you, I'd be picking up the phone. What's going on? Why haven't they been provided? I'd be having a look at your contract terms if you've got them, possibly getting some legal advice if they're going to still be difficult and not comply with their contract terms. A question here. I have an issue with an unreliable and untruthful vendor, but neither of these issues are in the contract. This is quite interesting because I'd certainly need some more information about what's gone on and how their conduct is unreliable and untruthful. But when you say these issues aren't in the contract, one thing that we do legally, it's part of contract law. A written contract has what we call express terms that cover a whole lot of different things. But it's also possible to legally imply, we say, a term into a contract and say that the parties are bound by that. And they're usually things that are quite common sense. For example, if it doesn't say so in the contract and it's a service contract, it's an implied term that the services are provided properly and of a certain standard. And you can claim that the other party is breaching an implied term, even though that term might not be written into the contract. In this case, it may be, and I wouldn't know until I had a look at the contract and got a bit more information, that a party is breaching an implied term, that the parties act in good faith in some way. Now, whether or not that amounts to a right for you to terminate or how to handle it, it might be that handling it might be a bit of a softer approach, might be putting something in writing and drawing their attention to the way that they are dealing with it. But yes, having a look at the contract and getting some more information would be the next step. Question here about what is the scope of LegalVision regarding international disputes? We do a lot of disputes where the other party might be an international, a company based in another jurisdiction. And it depends on what the claim is as to whether or not, as to how it can be resolved. If, for example, to come back to my debt recovery example, a company that's based overseas, say it's a US company, owes your Australian company money, then we can assist with, and often we resolve matters by, some early correspondence. But if it comes to needing to take legal proceedings, then we would refer to a partner in the US, and that type of thing often happens. We can't issue legal proceedings in another country. But very often we're dealing with disputes and resolving them, as I've said in the webinar, before things actually go to court. That's all I think we've got time for. I'm very sorry I haven't been able to answer all of your questions. Thank you for everybody for putting questions in. It's really great to see that you've attended today, and yes, that it's been that you've got some concerns, and I'm sorry I couldn't get to all of them. Please do claim your complimentary consultation, and we can discuss any of those concerns further. To claim the consultation, you just need to leave your contact details in the survey that appears when the webinar ends, or you can contact us via our website and confirm that you attended the webinar today. So thank you everyone for attending, and I hope that was some help for you today.